5 seconds to go. Start. He had examined the aforesaid PWs as eyewitnesses of the incident. The version put forth by the eyewitnesses meets a serious doubt when examined in light of the evidence of DW3 and DW4, the concerned Deputy Superintendent and Superintendent of Police respectively, who had supervised the investigation of the present case. Both these officers were examined as defense witnesses on behalf of the appellants. As per the supervision notes prepared by DW3 during the course of investigation, PW2 and PW4 got to know about the incident only when PW18 came running to them after the incident. PW2 at that time was sitting in a hotel with Umesh Singh to have prasad. Similarly, the evidence of DW4 indicates that on the date of incident at around 10 pm, PW4 was coming from Lakhisarai in his jeep and he saw 6-7 persons fleeing away in a jeep and he identified them as the accused persons. Thus, PW4 entered the scene after the commission of offence and he did not witness the act of abduction. The testimony of PW2 strengthens the doubt as he deposed that when they reached the police station after the incident with PW18, neither him nor PW4 informed the IO that they had directly seen the incident. The stark difference between the versions put forth by the PW21 and DW3, DW4 raises serious concerns regarding the fairness of investigation conducted by PW21, and it is a reasonable possibility that the eyewitnesses were brought in to create a foolproof case. The evidence of DW3 and DW4, both senior officers who had exercised supervision over the investigation conducted by PW21, indicates that the so-called eyewitnesses of the incident were actually accessories after the fact and not accessories to the fact. The sound limb of the objection against the testimonies of the eyewitnesses is that none of the eyewitnesses is an independent witness of fact. Ordinarily, there is no rule of law to discard the testimonies of the witnesses merely because they were known to the victim or belonged to her family. For an offence may be committed in circumstances that only the family members are present at the place of occurrence in natural course. However, the present case does not fall in such category. In the facts of the present case, the natural presence of the eyewitnesses at the place of occurrence is under serious doubt as discussed above, and for unexplained reasons the naturally present public persons were not examined as witnesses in the matter. The non-examination of natural witnesses such as Doman Tenti, Daso Mistry, Surdas, Kumud Ranjan Singh and many other neighbors who admittedly came out of their houses to witness the offence, coupled with the fact that the projected eyewitnesses failed to explain their presence at the place of occurrence, renders the entire version of the prosecution as improbable and unreliable. The eyewitnesses, being family members, were apparently approached by PW18, who informed them about the incident, and later their versions were fabricated to make the case credible. Stop.